The first thing, and I think the most important thing to understand about directors and officers liability is it's a fairly recent coverage. Again, as I said, it's only been with us for the last couple of decades to protect church boards, charitable boards, because really that's the history of litigation, has been only since 1987. And one thing to remember about directors and officers liability is that it is not intended to overlap with the general liability policy, which means that right off the bat, it does not cover bodily injury, property damage, or personal injury. However, what it does do is covers the organization and its board members for, generally speaking, their negligent acts, errors, omissions, misstatements, breaches of duty, or neglect of their duty. And examples of what it covers would be wrongful dismissal claims, employment practices, discrimination. This is a growing area of concern for faith-based organizations because most churches are operating on the basis of a statement of faith. In other words, you have certain standards or expectations which are scriptural for membership and for leadership. And when your board moves to remove somebody or discipline them, now you can sometimes get into a situation where the person doesn't accept that ecclesiastical authority and appeals to a court of law, to secular courts. Okay, and this is where we get into claims involving discipline and discrimination. And I'll talk a little bit about that later on. Other concerns for board members would be they have a lot of financial responsibilities. They're overseeing budgets, they're making contracts with other parties, they're in building projects, and they are using donor funds that may be designated or restricted for a particular purpose. And it's their responsibility to make sure that those dollars from the donor get used for the purposes they were intended. There are examples in Canada of board members who temporarily used restricted donor funds because their operating funds were deficient. They had deficits, with the hope that they could return that money when the operations started to become into a surplus situation again. That never happened, and the donors appealed to the provincial authorities, and the directors were actually required to personally return the money for the use that it was intended by donors. So again, it is important to understand that even though you're volunteers in leadership positions, the laws expect you and the regulatory bodies expect you to operate on the basis of this sort of standard of care. And the last example would be breaches of contract. In fact, just within the past week or two, we received another liability claim related to a charity that was in the midst of a construction project. And there were issues with the contractor. And because of time delays and cost overruns, the church and the contractor came to loggerheads. It's not clear whether the contractor abandoned the project or the church got rid of them, but now we have a liability suit by the contractor against the church board for breach of contract. Okay? So these are the types of things that are happening more routinely now. So points to remember on directors and officers liability: it is a more recent form of insurance protection based on current legal trends. It covers risks with moderate damages. And if you recall, when I was speaking about general liability, I said that it covered claims with the highest potential damage awards in a court. Directors and officers liability policies, because they don't cover bodily injury claims, the awards tend to be more moderate or lower in courts, generally speaking in the 5 or 6 figures. So it's still a concern, and many times these claims involve a lot of legal defense costs to protect the board members and defend them successfully. But again, the important point to remember is your directors and officers liability limit of coverage doesn't need to be as high as your general liability limit. Most organizations carry currently between $1 million and $5 million coverage for this type of exposure. Again, there's no overlap with general liability. The two types of liability coverage are meant to be complementary. It's a claims-made coverage, While general liability is an occurrence form coverage, one of the advantages of director's liability, especially for organizations who have never carried this protection before, is that it covers unknown claims and negligence that may have happened in the past when you didn't even have coverage, but could manifest themselves in the form of a liability action against you in the future. So again, even if your organization has never carried directors and officers liability coverage and takes the coverage out, it doesn't matter whether the claim happened this week or 5 years ago. You can still claim it under your current policy when the claim is made, as opposed to when the negligence took place. One of the important things to remember, however, with a claims made policy is that if you cease the coverage, it has no further obligation to cover any claims. So once you begin coverage, it's important to keep that coverage in effect so that it will cover past claims. And again, the same issue with directors and officers liability exists with general liability, and that is that most policies only cover compensatory damages, and it is important, especially for these types of exposures or risks, that you do make sure your policy covers all forms of insurable damages. As I mentioned, there is retroactive coverage, and this policy does cover probably the #1 cause of directors and officers claims is employment practices. Ex-employees suing for wrongful dismissal, and sometimes even current employees suing for employment-related harassment, discrimination, and humiliation. And it's unfortunate but true that even in Christian workplaces, there is harassment. It could be of a sexual nature. It could be related to more of a psychological thing. But probably a year doesn't go by that we don't have half a dozen of these claims in Christian workplaces. And they're based on people, I guess, as opposed to organizations. But it's important to remember that it can happen. Now, in talking about liability exclusions for directors and officers, again, this is a full table of what is excluded, but I'll break it down into 2 categories again. What is not insurable is bodily injury, property damage, and personal injury, precisely because it's meant to be covered under general liability. It doesn't cover abuse claims because they're a form of bodily injury. It doesn't cover fraud or criminal acts committed by the directors themselves. Again, they can't expect coverage for situations where they break the law. Negligence is one thing, criminal action is quite a different thing. And again, some other standard exclusions. Now, risks requiring special coverage, again, we talked a little bit about professional services, if your organization is providing those to other organizations or individuals. And also, there is a small risk sometimes related to national bodies or organizations that, for example, denominations or umbrella associations that have employee pension plans, and pension plans to cover or to for the benefit of ministers, for employees, or for members of an association. This is called fiduciary liability, and it's important to have a fiduciary liability policy to protect the organization and its pension plan trustees in case they're sued by plan members because the plan members' assets have been eroded or the trustees handled the money negligently. And those pension plan members now have far less assets for their retirement than they had anticipated.